was worked on time ever.
We can get started with the family law calendar. First case, Nicole Walker and Jonathan Walker. All right, in the absence of any response, I will make a finding of adequate cause. I'm not ordering any modification to the parenting plan at this point. Just if there's adequate cause to proceed. You understand that, ma'am?
I'm wondering if if his paperwork that he served me is still valid. He served me on the 28th and I was supposed to have a response by the 26th. Does that make his paperwork no longer valid, or?
I'm not understanding what you're asking.
He served his paperwork to me on the 28th of September, and
Okay.
I was supposed to have a response filed by the 26th of September.
Well, again, you're saying he served you and your response was due 2 days earlier?
Yes.
I don't understand what you're saying. But what I'm doing today is finding adequate cause so the motion to modify can go forward. That's all I'm finding. And it's still going to have to be set for either an agreement or for trial. All right. And that'll be all. Thank you.
Thank you.
I'm here, Your Honor.
I'm here.
And we have Ms. Height. And so, folks, I'm looking at a set of paperwork. Includes the findings and conclusions, decree of dissolution, parenting plan. Are you all agreed on this? Is
Yes.
that correct, Mr. Goebel?
Yes. Yes.
And Ms. Height, you're comfortable with the parenting plan?
Yes, Your Honor.
All right. We also have the testimony by affidavit. So I'll sign the order dismissing the GAL. Let's see, ma'am, you were married in 2012. Is that right?
Yeah.
And separated in July of 2021.
Correct.
And you split all your property, all your debts.
Yes.
And is the parenting plan that's being proposed the one that you have been using?
Yes.
And that's working for you?
Yes, it is.
And you're comfortable with the child support order?
I am. Yeah.
And Mr. Goebel, is all that correct?
Yes, it is.
Right, folks, I note that your parenting plan is a week on, week off. I know people who have grown up in those parenting plans. They can be real tough if the parents aren't cooperating with each other because the kids kind of feel like they're living out of a laundry basket. So it just makes it real imperative that you guys work together for the sake of your child. I'm sure you understand that, right?
We do. Yeah.
Okay, good.
Yes.
All right, I will sign the decree, parenting plan, child support order. Thank you very much.
Thank you.
Thank you.
And Ms. Height, where do we stand?
Your Honor, both parties have returned their intake packets and we are getting underway. We have some appointments to have interviews and I think we've got some traction.
And the state have any input at this point?
We've just entered our notice of appearance and we're filing a motion for temporary child support. So nothing relevant for today.
All right, thank you. Okay, then I will strike today's hearing. I assume the state will put it on shortly to address the child support matter. Make sure you follow through with those appointments with the guardian ad litem.
Okay, perfect.
Thank you, Your Honor.
Thank you.
That matter, Your Honor. Kurt Anagnostic representing Christopher Crocker.
And I see Ms. Acevedo.
Aye.
All right, Mr. Anagnostic.
Yes, this is my client's motion. My client filed a petition to establish a parenting plan with Miss Acevedo. Prior to that, the two children, we're talking about Samuel, who's 3, and Calliope, who's only 11 months at this point, primarily lived with my client. They had always lived with my client in his home. He has a large 4-bedroom home. They have all their things there, their personal property there. They live there. Miss Acevedo would come there to see the children, be there for a period of time, then she would leave. There was a period of time that she was out of the residence from October 22nd to February 23rd with little contact with the children. Then she showed up again. She's a bartender by trade, so she'd be there maybe a couple of days during the week, and then she'd be gone for most weekends, and not very much caring for the children. But she then took the children. My client attempted to get them back. Ultimately, there were issues, and she called the police, and my client got charged. Anyway, those have been since dismissed, but he hasn't been able to see his children. So we're asking that the children be returned to my client. They need to be returned to my client, to their home where they've been raised. And then we set a visitation schedule for Ms. Acevedo. We got to be concerned because she has a relationship with a sex offender. And we provided the criminal sheet regarding Gary Hayden, who has a rape of a child and a 3rd-degree conviction. And my client, that's what precipitated this. My client went to get the children and get them returned to their home. And then she's refused since then. And without order, she attempted to get an emergency order from the court here that was denied, and it was set up for this hearing. So we're asking today that the children be returned. And if the court, is going to consider a residential schedule at this point, it'd be, after a full drug assessment evaluation on Miss Acevedo, and some kind of orders in place that the children will not be around Mr. Hayden. Those are our requests. The parties had previously talked, and they were working on a split visitation arrangement of 3-4, 3 days with one, 4 with the next, and then 4-3. So it would be a split schedule, but it would rotate during the week because of Miss Acevedo's work schedule, being a bartender on most weekends and stuff. I guess the court can consider that, but I think it should follow some kind of full evaluation on Miss Acevedo and drug and alcohol assessment. And she has, as indicated in my client's declaration, some bipolar issues that are not being treated. She's not gotten into recommended counseling, and there are significant issues and concerns. The children need to be returned, and then we need to start a process of what's going to be in their best interest moving forward so that they're protected.
Ms. Acevedo, what do you wish to say?
Hi, Your Honor. Couple things. I'm not in a relationship with the man in question. I went on a date with him a couple times at the beginning of the year, learned his name was not what he told me it was. I'm also not in a relationship with him. Currently, Hayden Hess is in custody in the Cowlitz County Jail for some stuff that does not involve me whatsoever. I am not homeless. I'm not on drugs. I live in my dad's house. I lived in Chris's house until December 26th of 2022, which Chris and I agreed upon when I broke up with him in October due to the unhealthy nature of the relationship that we had with one another. I stayed in the house through the holidays. I have thousands of photos of all 4 of us together through these months he claims that I was missing. I moved into my dad's house. I've lived there ever since. I do not bartend anymore. I'm right now full stay-at-home mom. I'm more than happy to comply with any drug test in question because I have not done any substances. The reason why Christopher and I are having these problems is because 3 times this year, I have caught him doing fentanyl oxys, and he went to Rainier Springs down in Vancouver twice to detox and did 1 at-home detox. He admitted all of this to me. I have a recording of a video on my phone of him talking to his mother about his drug use and her instructing him not to text me the messages, only to do it over because it could
Hearsay.
Yeah, ma'am, we need to limit ourselves to what's in the affidavits that have already been presented.
I have no drug use. I have a home. I have a car. I'm not working currently because I'm focusing on the children and I have the means to do that without work at the moment. I'm not using drugs. The reason why I've been keeping the children from Christopher was his drug use. 3 times this year, he has been smoking drugs off of tinfoil in the house where the children are. That's how I caught him the first time, as I found the tinfoil. He went to detox. He came out, said he was clean. Realistically, he later admitted he got into his vehicle and used immediately after getting out of the detox. He did an at-home detox where his mom babysat him. And then I went to pick up the children on August 13th and he admitted he had done it.
Just a moment, ma'am. Mr. Anagnostou?
This is not contained in any kind of declaration before the court.
Yeah, there were some references to it all on it. Go ahead, ma'am.
I'm not using drugs. I'm not a danger to the children. I am not in the relationship he claims that I'm in. His accusations towards me are false. And his declarations, all of his parents and friends claiming to have seen me use drugs, they're all lies. Because I know I haven't. I am more than willing to drug test because I've been clean and sober for many years. I haven't done any illegal drugs whatsoever.
All right, Mr. Anagnostou?
Just briefly, Your Honor, the children resided primarily with my client. He hasn't got to see them, because of Ms. Acevedo's actions, and this needs to be resolved for the children's benefit. They need to be returned to their home.
The children lived with Mr. Crocker.
Ma'am. All right. The children will be transferred to Mr. Crocker.
Your Honor, please.
Ma'am, you need to listen to me at this point. If you don't, it's going to cost you money or other things. So the children are going to be returned to Mr. Crocker at 5 p.m. tomorrow. They will then be returned to Ms. Acevedo at 5 p.m. on Tuesday. We're going to review this next week on this same calendar. Both parties are to do a urinalysis and hair test immediately, and we will see what those results are next week. If either side doesn't do the test and have results next week, the test will be presumed positive and we will go from there.
I have one more question, Your Honor.
What's your question?
Mr. Crocker currently has a case open involving the children and recklessly endangering our son's life. It's an active case and it doesn't resolve until October 18th. He's got 2 charges for reckless endangerment pending against him and false information to a police officer and obstruction. And our son was involved in that matter. He was driving at 80 miles per hour in a 35 with our son unbuckled in the back seat. And
I suggest you file copies of that report so I can review it for next week. The children are to have no contact with Mr. Hess.
You should have copies of that report already.
I do not. All right. So the kids are to have no contact with Mr. Hess. Everybody is to behave perfectly appropriately. And we will review this next Thursday, the 12th, at the same time.
Your Honor, Amy Powers for the state. Can we address child support next Thursday as well? We filed our proposed child support worksheets on September 22nd and sent them to both parties.
That's appropriate. And we'll also address getting a GAL next week as well.
Thank
But
you.
I want to make sure both parties understand that they are to do those drug tests immediately. If I don't have them next Thursday, I'm going to assume that whoever didn't provide them is using. That's the only option I've got.
Yes, Your Honor.
You understand that, ma'am?
Yes.
All right, that will be all.
Your Honor, just clarification. So my client gets them, the children tomorrow at 5 p.m. and returns them at 5 p.m. on next Tuesday.
Yes, sir.
The exchanges, we would like to use a third party to do the exchange, either her father or my client's father.
Any objection to that, ma'am?
My father will be doing it, yes.
All right. That will be all.
Thank you, Your Honor.
I literally can't believe that just happened.
I can't either.
So you have the
yeah.
police.
I don't.
Mr. Walker, I called your case earlier. Ms. Walker was present. You weren't. I did
Oh.
sign the order finding adequate cause to proceed. I didn't make any other findings or rulings other than that. You understand that, sir?
Yes, I understand. I did submit some documents this morning, but obviously you weren't going to be able to get them in time. But I did have a response to hers.
All right. So if you want any sort of a court hearing on any of the issues, you'll need to note that on yourself. You understand that?
How would that be? How would that be done?
You'd have to file a motion and note that up for a hearing.
Okay, so file for another hearing
Yes, sir.
for this. Okay. So okay. I just want to make sure I'm clear. So you said that
So,
you
yeah,
signed.
the only thing that happened today is I found there's a basis to go forward.
Okay.
On that, there are no other rulings.
Okay. All right. Okay. Well, thank you.
Thank you.
Yeah.
All right. Do we have Rothmandia Stetzer or Joel Stetzer?
Yes, we're both here. Hello? Yes, we're here.
Yes. All right. And I've got proposed findings, decree of dissolution, child support worksheets, and parenting plan. Have you both been over these documents?
Oh, yes, we
Yes.
did it all together. If you'll excuse me, Your Honor, we agree on everything that's in the documents. We did it all together.
And is the parenting plan the one that you've been following?
Yes. I mean, occasionally, she takes my son or I take him, yes.
This is your starting point already, right?
Pardon, sir?
This is what you're doing
Yes.
already by and large, okay?
Oh,
And
yeah. Months.
Sam, you're comfortable with the child support order?
We're comfortable with whatever is ordered.
Okay. There's a proposed child support order.
I've been paying way more than child support. And I think my wife right here will tell you the truth. Not
Okay,
only
well,
paying child support,
is the state involved in this matter?
the state? Pardon, sir? I'm sorry.
I'm asking the prosecuting attorney's office there.
Oh,
Stepped out.
Excuse me.
Is the child receiving any sort of state benefits?
No.
And ma'am, you're asking that there be no child support?
Yes.
Okay, and is Mr. Stetzer paying a school tuition?
Yes.
And how much is that a month?
$688.
And has all your property been divided?
Yes.
And are all your debts divided?
Yes.
The only debt is the mortgage on the house, and she's keeping the house.
And is your marriage irretrievably broken?
Yeah. Yes. Yes, it is.
That's okay.
And ma'am, you're asking if your last name be changed to Kong, K-O-N-G, is that right?
It's correct.
All right, I will grant the decree.
Thank you.
Thank you.
That matter's ready, Your Honor.
And counsel, this was over from last week, kind of to see where we were ending up. Have we ended up anywhere?
Yes, Your Honor. It appears that in the interim, Judge Scudder has actually signed an order terminating all the emergency guardianships. The child went back with father. Child contacted me last night, would like contact with mother as well. So at this point, we did put in a motion to transition custody. And that's just for father to continue treatment. But at this time, my client just wants to be back with her parents.
And let's see. Looks like we've got both the parents here. Anybody objecting to that?
No.
No.
All right, then I will strike the matter, and I believe, as was stated, that guardianship is now dismissed.
Thank you, Your Honor.
Thank you.
I was wondering if the restraining order on Kristen Kearney was gonna go through, because she's been outside of my.
That's another case that's not in front of me. I don't know anything about it.
Okay. Alrighty. Thank you.
I'm here, Your Honor.
Amy Powers for the state of Washington.
I see the petitioner, Michelle Leeper, is here, and I received an email from Mr. Lee just a little bit ago indicating that his client is in agreement. Father has already signed off, and those orders should be presented ex parte on Monday. So this is an agreed matter that should be done and finalized by Monday.
I did speak with Mr. Lee this morning. He was planning to be here. Would the court want to recall the case?
I just see him. He just hit the waiting room, so letting him in now. All right, Mr. Lee, I'm told the Leeper matter agreed orders will be entered on Monday. Is that correct?
Good morning, and yes, Your Honor.
All right.
The one remaining issue is that the child is on TANF, and so we want a child support order entered. We sent over a proposed order. We're setting father's support at $50 a month. He receives SSI. For the mother, we imputed her at minimum wage. But I left the deviation section blank in case the court decides it's appropriate to deviate downward based on the factors that led to the minor guardianship.
Yeah, and my client has no objection to that, Your Honor.
I believe our office sent over 2 final child support orders, one for each parent, and then also the worksheets.
Yes. All right, if counsel doesn't mind, I'll go back through and review for some sort of deviation for the mother, because I think that's probably appropriate. I will sign the order as to the father.
Thank you. And when you make the decision on the deviation, if you can just write in the transfer payment in paragraph 10.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Do we have Ms. West?
I saw her a moment
Yes, I'm here.
ago.
All right,
I'm here.
we go. All right, Ms. Dow, where are we?
Your Honor, I believe we need to hear from the court visitor, Sherry Farr, today. There was an order signed for appointment, but I mistakenly left off the financial portion of it. So an amended order was signed. She's received that order. I believe she is going to want to address the court as to what sort of time requirements she's got. I'm assuming that we are also then going to have to extend the temporary order. I delivered a proposed form of that order to the court yesterday, which I hope you have in front of you. If you don't, well, I'll make sure it gets to you. But I believe we need to hear from Ms. Farr.
Doesn't look like I have that order, but okay, we'll check for it after this docket's over. All right, Ms. Farr.
Good morning, Your Honor. So I did just receive the amended order yesterday and I haven't started on this case. So I would request that I be given some time to get the investigation going.
If anybody else here present on that matter?
Yes, Your Honor. Good morning. Delana Jones here on behalf of respondent mother Marlene Melton, who is also present on the Zoom platform this morning.
And any objection to the requested continuance?
Not necessarily. We understand that Ms. Farr needs time to conduct her investigation. It hasn't been discussed the length of time that she's requesting. And based on that length, we might run into some timeline issues procedurally regarding the amount of time the emergency guardianship has been pending. And we would also then, for a longer request, request that some sort of overnight or daytime visits be implemented in the interim for the mother respondent. I believe Your Honor has looked at the court file, voluntarily took a urine analysis, has income, provided information regarding where she's residing. The child has his own room. The petitioner says that the child is recovering medically just fine. He's in school, so weekend visits, I don't see any sort of argument for substantial harm for that in the meantime.
Ms. Farr, how much time do you think you'll need?
Your Honor, I think probably a month. I have a heavy caseload and I haven't even started reading the pleadings in this case yet.
All right. And Ms. Dow, what's your position about contact pending?
Your Honor, I would have to confer with my client about that. She was supportive of contact previously until she became concerned when it looked like things were not getting done that needed to be done for the child. Right now, we have telephone calls arranged. I'm sorry, Your Honor, I would have to talk with my client about that.
How far apart are these folks physically?
Physically, my client is here in the Longview Kelso area, and I believe Ms. Melton is in Everett. Is that correct?
That's correct. Typically, the parties previously met in Olympia for their historical weekend exchanges. So I would presume that they would just meet at the same location that they have been meeting at for the past several years. And I would say for the phone calls, they're not really going that well. They're not always consistent. We don't always get a response from the opposing side regarding scheduling. She has her, the mother has her work schedule, which conflicts sometimes with the child's out of school hours. So really a month-long continuance is detrimental to their, relationship. They need some time together.
What's Ms. Melton's work schedule?
We did include it in one of our filings. I'll pull that up, but typically either, I believe, Tuesday to Sunday or Monday to Saturday, with sometimes evening hours of 4 p.m. to 10 p.m. But I believe that she could make arrangements to have time on the weekend available to be with the child. Typically, the parties used to exchange Friday evening to Sunday.
And Ms. Melton, are you going to be working evenings in through the next month,
Yes, but I can change my schedule around to work mornings instead.
Does that create any problems for you if you do that?
No.
All right. Thank you. All right, we'll set a review hearing in this matter for November the 9th at 10:30. Pending that, Ms. Melton should have telephone contact with the child twice a week. It sounds like Tuesdays and Fridays. If you work days, what time would you get off, Miss Melton?
About 4 o'clock.
Okay, let's make it 7 o'clock. And we'll see how those are all going when we're back here in a month. And I think that covers everything.
And
The court's denying the request for any daytime visit, even if it's not over.
We'll defer that at this point, given the distance involved.
And Your Honor, the order extending the guardianship that I delivered to the court did not have a date on it.
We'll use that November 9 date.
All right, I will contact the court clerk and make sure that that gets filled in properly and submitted for ex parte signature.
All right, thank you.
Thank you, Your Honor.
Thank you.
And Your Honor, I am wondering, is it not required for the petitioner to file? I know we have the order extending the emergency, but in terms of timeline beyond the 60-day, whether an additional petition is required to be filed?
I will leave that to Ms. Dow to file at this point. I don't want to make a
We can
ruling based on things that haven't happened yet. So
we can work on that, Your Honor. Right now, we're at 38 days. So Ms. Jones is correct that by the time we get to November, we will be past the 60 days. But if I'm not mistaken, well,
don't we
Ms.
only
Jones and I will work that out.
the unfortunate, we're just discussing, the statute's a mess. It's complex. It has internal inconsistencies. So look very carefully to make sure that you hit all the timelines.
I will do that, Your Honor. Thank you.
For clarification, I believe only the immediate emergency order is entered, not the actual emergency order. And the immediate emergency order doesn't have a timeline on it.
Okay, I will sign the order that extends the emergency guardianship through that November 9 date.
I'm here,
Thank you, Your Honor.
petitioner Christine McElwain Conley.
And have we got anybody else? Ma'am, we don't have any proof that anybody's been served with any of the paperwork. So at this point, I can't do anything.
Yeah, that's kind of what I was afraid of. I flew to Pennsylvania because the paperwork, she was unwillingly removed from my home on Friday, about 2 hours before I received the paperwork. I was told she was in Pennsylvania, so I went there to try and serve and actually get her back, but that didn't work out. Things with Alabama are in question because I've been in contact with caseworkers to help with that, and I'm getting stalled. I'm not even sure at this point where she is.
All right. Well, as I said, I can't do anything further because we don't have proof of service. I'll strike the matter today. If you find that out, you may have to deal with the state that she's located in.
Okay.
It gets very complex.
I understand that. I can't give up on her because she's telling the truth.
I understand what you're saying, ma'am. And I wish you luck. So, but we'll strike the matter here. You can restart the process if and when you find
So
it.
is there a possibility to get an extension instead of striking it?
No, I'll strike it today. If you do make contact and have a path to pursue, you can bring the matter back.
So refiling.
Yes.
Okay.
All right. Thank you, ma'am. And counsel, have we got service yet?
Your Honor, we haven't been able to locate the biological mother. We have gotten consent from the biological father, however, which has been filed. So I guess we're kind of at an impasse currently pending that And we were hoping today to move forward. We understand if the court has reservations on that, but we do want to note that the father has consented. We just are unable to locate the mother at this time.
This may be a silly question, but have you got any kind of a guess on time frame when you might be able to do that?
Your Honor, we're going to attempt further contact with police and other just state officials that might have contact with her. I would hope to get at least an update by the end of this week. But I would imagine if you're requesting that info for idea of a set over, my guess would be at least a week, possibly 2 weeks.
All right. We'll set this for the 19th. I will extend the emergency guardianship through that date.
All right, thank you, Your Honor.
And do we have anybody else here on the Oxford matter?
Started finally.
Pardon? Do we have anybody else on the Oxford matter? Would appear not. Okay, so ma'am, when last we spoke, you were going to get a petition filed to extend the current guardianship. What's the status of that?
No, sir. She was run away. I contacted the police. Her mother actually came and picked her up on Sunday. So she's no longer in my home. And I'd just like to cancel the guardianship or whatever the process is. I'm not even sure what the process is.
You're not, don't wish to pursue it at this time, is that right?
No, she was very belligerent and destructive and abusive towards me. So I don't want her back in my home.
All right, I will sign an order terminating the minor guardianship.
Okay. Thank you, Your Honor.
Thank you. And I believe that is all.